Hey, welcome back, everybody. It's Monday. It's Law and Legitimacy. I know. You didn't put the pot roast in the oven on Sunday. You told your mother you couldn't come over because you were going to listen to us. And your wife gave you a honey-do list. And you said, honey, I don't is my word. Get me a honey donut because I'm going to be listening to Law and Legitimacy. These guys are going to be talking at 2 o'clock on Sunday, as we promised on Friday. And there we weren't. Hey, guys. Let me put it to you in PG-13 terms. Feces occur. We had communication problems. We couldn't get it up, so to speak, and therefore we weren't here. But here we are today, and oh, what a world!
Yeah, the blame lays at my feet, so no one needs to blame Norm for the weekend hiatus. That's on me. I'll own that, and it was. And internal comms, as I think I referenced on my end, that got a little twisted up. But the weekend was great on this end. Love spending it with the family. It was beautiful. North Carolina, I think we had like 6 or 7 days worth of rain straight. So, things were crazy. People were out and about, and it was beautiful here right after the solstice, summer solstice. So no regrets here, but do apologize for the last minute update to everybody. We did send out a tweet. So if you're not following us on Twitter, maybe a bad faith argument to make here. You should follow us on Twitter, hit the notification bell. Anytime we do something like that or make a change, you'll get a notification. But glad to be here this morning.
Hey, good morning, Luttrell. Good morning, Freedom Lover. Good to see you back. So, we were going to talk about eminent domain and what's going on in South Dakota, and will later in the week. But in the meantime, we had a blockbuster of a decision in my firm. And it's been all over the news, coast to coast. And so I thought I'd talk briefly about it to bring you up to speed. It's the case of Saifullah Khan versus Yale University. There's a story about it on Law 360 this morning. It's been a source of some controversy. And here are the facts. Saifullah Khan was a Yale student, a young man who was recruited from Afghanistan. Somebody spotted him in a refugee camp. His family had been driven out of their home by the Taliban. One of his relatives killed by the Taliban, and there they were living in a refugee camp. And somebody spotted him and said, "Boy, this kid is brilliant. He should go to Yale." And so he was given a visa to help Yale help them. He goes off to Choate, a finishing school here in Connecticut. And next thing you know, he's go choke yourself. No, not choke. Choate Rosemary Hall, I think it was, or maybe it was. Well, in any case, he goes off to finishing school. If it wasn't Choate, it was my mistake, but it was one of them. And he goes to Yale. He's now a senior in neurosciences. It's Halloween night, and he ends up with a classmate in her room under circumstances that led her in the morning to cry rape. And his view was, it didn't feel like it at the time. I thought there was consent. He's immediately thrown off of campus. We get a stay of the administrative proceedings because he's also been criminally charged. And we go to trial with him in New Haven. He faces a sex assault in the first degree, the most serious sex assault there was. We also asked the judge to charge lesser forms of sexual assault as alternative offenses, something that you criminal defense lawyers will know as lesser included offenses. So he was charged with sex 1, sex 2, sex 3, sex 4. The jury acquitted quickly of all 4 counts, and he was a free man. He goes back to Yale saying, well, I've been acquitted. Can I come back now? They let him return to classes, but not to campus. He can't live on campus. He's off campus. They begin administrative proceedings, and the Me Too groupies get wound up about this and start demanding his removal. He has an administrative proceeding. I represent him as at that as well. I'd represented him at the criminal case. But at that criminal proceeding, the witness against him was not required to appear. She was not required to take an oath. He had no ability to cross-examine her. We asked for a copy of the record to be kept for purposes of any appeal, and I was not allowed to do anything, even to speak while present in front of the committee. I could simply sit there and offer such mute assistance as I could. Unsurprisingly, he was removed from Yale, and then we filed suit. We filed suit under Title IX and in federal court. He now lives in another state, so it's what's called diversity jurisdiction. He was from one state. Yale obviously is here in Connecticut. We also sued the complainant, Jane Doe, whom we didn't name out of respect for Yale's administrative process. The lawyer for Jane Doe, a separate lawyer, moved to dismiss our claim, saying that the young woman enjoyed what's called a quasi-judicial privilege. Now, privileges and immunities, those are things that the law grants to people that permit them to do some things and not others, but more to the point, permit others to do some things and not others to them. What do I mean by that? When a person testifies in an official proceeding, in a judicial proceeding, in a courtroom, they cannot be sued for their testimony. They have an absolute privilege, a judicial privilege. The lawyer for Jane Doe took the position that Connecticut recognizes a quasi-judicial privilege, and that because this was a quasi-judicial proceeding, it wasn't a courtroom, therefore we shouldn't be able to sue her. The district court judge agreed with Jane Doe's lawyer and dismissed the action. We said this was a kangaroo court. This wasn't a quasi-judicial proceeding. So we took an appeal to the United States Court of Appeals for the Second Circuit. The United States Court of Appeals for the Second Circuit in New York City said, well, we're not the Connecticut Supreme Court. This is a close issue in Connecticut law. So we asked them to certify this question to the state Supreme Court to make a final determination of what Connecticut law is. And you're saying this is a lot of time. And yeah, the case is now 8 years old already since the Halloween event in 2015. The lawsuit was filed shortly after his acquittal in 2018, and we've been fighting ever since. The state Supreme Court last week, in a shocking decision, concluded 7-0 that Yale's proceedings are not quasi-judicial at all. They lack fundamental qualities that any judicial proceeding would have. 5 of them in particular. Complaining witnesses are not required to testify under oath. There is no right to cross-examine those witnesses. When this woman was questioned by the university-wide committee on sexual misconduct, the UWC as it's called, we weren't even permitted to be in the room. And she was there by video, so we had to listen in another room. And if we wanted to ask questions, we had to submit those questions to the UWC, who decided whether they would ask them at all. The record, according to the Supreme Court.
May I read just directly from the opinion, or from the decision rather? Quote. The plaintiff's counsel was not permitted to speak, question D or any other witness, or raise objections, and the hearing panel denied the plaintiff's request for a recording or transcript of the hearing. Additionally, the committee's procedures allowed the parties to submit questions that they wanted the hearing panel to ask, and to request that the panel call witnesses to testify, but the panel had the sole discretion to reject the proposed questions or witnesses. The university ultimately expelled the plaintiff.
Yeah, treating me, the Supreme Court famously said, like a potted plant. The court said that it wasn't clear on this record that the defendant, or Mr. Khan, the plaintiff in this case, had the ability to call witnesses. I think he did, and I'm not sure the Supreme Court got that right. Then he was also deprived of the active assistance of counsel, and he could make no record. In other words, there was no transcript, thus undermining his right to appeal. And so the Supreme Court said, because this was not a quasi-judicial proceeding, Jane Doe was not entitled to qualified privilege. And so now the case goes back to the Second Circuit, where they will issue a decision based on what the Supreme Court's ruling on these questions of state law, and then they will send the case back to the district court for further proceedings. And we expect it to arrive there late this summer and early in the fall. Once that happens, then and only then will discovery begin in this case. And it's a great win for us at this juncture, signaling as it does the defects in Yale's administrative hearing process with respect to complaints of sexual misconduct. It's not a guarantee that we'll win. We're going to have to go out now and prove various other parts of our claims, including that Ms. Doe acted with malice as to Mr. Khan. And it's our contention that she was made a stalking horse for the Me Too movement, and that when they teed off on Khan, he was a victim of political pressures.
Right. So this is all 2015, and I think it's easy for us to just sort of be attracted to the flavor of the month as sort of cultural zeitgeist go. But this is at the, I would call this the peak of the Me Too movement, right, Norm?
Yeah, no, it was.
And,
So, but
and
yeah,
my question for you, because this is monumental. I think the case was premised on defamation, but also tortious interference with business relationship. These are all claims that that Khan is bringing against the unnamed woman that alleged that he raped her, right? And everything was dismissed. So now he's on his mission to clear his name and his reputation, right, and to restore the losses that he no doubt incurred. And that's why you spent the first part of the stream talking about how talented of an individual that
let's talk. Let's talk about his damages. I mean, Yale has a $40 billion endowment. That is, in other words, there ain't no shortage of dough at Yale. And so here's what they did to Mr. Khan. They lured him to come over from the refugee camp in which his prospects were bleak, and recognizing his talents, they offered him the world. They said, "Come with us, trust us. We will make you part of our community. We will give you one of the premier undergraduate degrees in the United States, and then you can blossom, soar, and accomplish your wildest dreams." Well, what that wild dream turned out to be for Saifullah Khan was thrown off of campus and rendered homeless by a university that brought him to the United States and then subjected him to a kangaroo court that was where his claims were not seriously entertained by the university. And a young woman defamed him by making accusations that he says, and fact finders, at least in the criminal jury context, found were false. What's that worth? Yale is notoriously cheap when it comes to settling lawsuits. They guard that endowment with their life. Do we ask for $1 million? Do we ask for 10 million, 40 million, 400 million? Do we ask for 10% of their endowment?
Well, I heard there's a judge out of Connecticut that is pretty liberal with respect to damages awards.
That's where I'm going. I would have thought this case had a value, but not necessarily an astronomical value until I think of the Alex Jones case. 1.5 billion for his comments and conduct after the Sandy Hook shooting. This strikes me as far more egregious, or at least as egregious. So maybe $1 billion is in Mr. Khan's future. We'll see. You'll find out. Stay tuned. As the case progresses, we will report on it from time to time. But in terms of the Title IX community, and that is that body of law that is developed to challenge the permissive administrative hearings that obtain in universities from one end of this country to the other in their evaluation of claims of sexual misconduct, this case has historic consequences and is resonating coast to coast.
Freedom Lover makes this comment, and I want to give you just a quick moment, Norm, to respond to this. Freedom Lover says, falsely accusing someone of rape should be a crime itself. Is it not?
Well, you can say there's the crime of filing a false complaint, but this is the problem in the litigation system. When you go to trial, one person wins and one person loses. It's a zero-sum game. If you could bring an action against every loser, because their loss necessarily means the jury found the complaint was false, you'd just be multiplying litigation. And so I think, could the state charge her with perjury? I suppose. Could the state charge her with filing a false report? I suppose. But I think the state has made an investment in the witness, and they're prepared to say that they tried the case, the jury rejected the claim, but they still believe her, and they're choosing not to prosecute. And as a matter of public policy, if you want finality in litigation, I don't think we want to encourage a regime in which the state at least puts his thumb on the scale, right, and says we're going to exact vengeance against losers, because really, that would deter people from going to court.
That's right. And so the real answer to the question then is the fact that this is exactly what Mr. Khan should be doing. It's retaining a private lawyer and suing in a civil context, right? Piercing the various thresholds that need to be pierced, making the allegations. And I think the additional threshold of actual malice as it exists within the defamation framework, everybody should recall that the First Amendment, guarantee of free speech has a number of limited exceptions. Defamation and libel exist within those exceptions, right? And this would be a clear case, if proven in the court of law, that would represent exactly what a society like ours should expect of its citizens, is that, if you're going to say things that are untrue, at least do so in a good faith way. But if you have credible reasons to believe otherwise and you are going to damage someone else, you will reap the consequences. So that's essentially what Khan now has the ability to do, is proceed forward. This isn't a disposition on whether, she's liable or not to Mr. Khan. This is simply the Connecticut Supreme Court allowing Mr. Khan to continue forward with the defamation lawsuit.
And you know what? And I think the interesting thing at oral argument, the Supreme Court expressed puzzlement about the fact that while Jane Doe had filed a motion to dismiss and was responding to our appeal, Yale had taken no position. And I think there's a shrewd tactical reason for Yale not to do so that reflects in some respects the vulnerability of our case going forward. It's by no means a slam dunk, certainly as to Jane Doe, and maybe even as to Yale. And here's why. On a motion to dismiss, as a matter of civil procedure, the trial court and the appellate court is required to accept as true the well-pled allegations of the complaint. So we pled the facts we think we can prove, but we haven't proven them yet. And so the complaint makes assertions that that the court held that even if the trial court, even if those assertions were true, we weren't entitled to relief because of the privilege. We've now won the right to seek the relief, and we've now won the right to try to prove our claim. But I can tell you, as a tactical matter, I have a heavy heart with respect to Jane Doe. I cross-examined her and saw her testimony in open court for a day or two, or maybe even 3, in the New Haven case, and it was difficult, gut-wrenching work. And I believe that it is a very difficult time for her today, comprehending and coming to understand that she will be returning to the adversarial process. It's likely, in my view, that Yale will attempt to settle the case, at least on her behalf, while seeking to vindicate its procedures. The smart thing to do would be for Yale simply to amend, reform its procedures to accord better due process rights for students, and reach out to us to settle. But candidly, I don't know whether Mr. Khan is going to want to settle or not. That's a topic for another day. Let's move on. Remember ChatGPT and the lawyers.
Quickly update, because I know, Norm, you're on a hard stop today. You're being a real lawyer, so we don't want to waste time. But I did want to at least get this on the record for our viewers and listeners. We brought up the case a few weeks ago out of the Southern District of New York, whereabout the attorneys for one of the parties in a civil suit, or a couple of the attorneys, had promulgated documents to the court which cited cases that did not exist. That is right. Those cases were generated by ChatGPT. And the defining feature of this fraud on the court was not that it was discovered, but that the attorneys representing the client for whom they use these made-up cases as persuasive or binding case law that the court should follow, doubled down and still attempted to use them in the court proceedings. And it wasn't until about May 25th that the truth began trickling out. And so we are now at a point where the court, they issued the show cause order. We followed up all the way through there. And I think what has happened, I've got this document and this article on the screen from the Volokh Conspiracy detailing the opinion handed down by the court. And I think, Norm, you and I, just skipping to the end, are a little bit underwhelmed. What ends up happening with all of these blatant and bad faith, and I'm using bad faith in air quotes here, right? Because this is something that the court used, but bad faith violations of the Rule 11 attorney ethics provisions only results in a penalty of $5,000.
Yeah, no, I read through. It's a 40-some page decision by the trial court judge, whose name escapes me right now. And it was stinging. I mean, these guys deliberately lied to the court, doubling down, as Mike put it. I'm not sure that's the expression that the court used. They failed in their obligations, not just to their client, but to the court. They engaged in fraud, in effect, on the court. And so as I'm reading through this, I'm thinking, well, let's see. I got suspended by a rogue judge for 6 months for sending documents to my co-counsel in a case that the court believes I shouldn't have sent. His office hit the send key by mistake, sending them to another lawyer. These guys are going to get suspended. And then I saw a $5,000 fine for fraud on the court, because the penalty in the judge's mind should be no more than necessary to accomplish the purposes at hand. I'm thinking, wow, that's a lenient judge. It's a devastating ruling. These guys will recover a $5,000 fine. It's, in my view, a misdemeanor for a murder in this case. The truth was,
I agree.
The truth was the victim's society was imperiled, and these lawyers have been given a slap on the wrist and told to go and sin no more. Oh, to be a New York lawyer.
Yeah, I mean, wild. Because look, it says acted with subjective bad faith in violating Rule 11 in the following respects. And these aren't, again, I don't want to sit, but I mean, these aren't trivial circumstances. I mean, the fact that you have licensed practitioners before a court that owe that court an absolute duty of candor, right? And owe a duty to opposing counsel. They owe duties to their clients. And the fact that they were not only using something that was wholesale, just generated out of thin air by ChatGPT, right, in court filings, but they sought to use those and perhaps explain them away in some respect. It's sick. And for this court to just say, hey, $5,000 and it's all good, it's ridiculous to me. It's ridiculous.
On the topic of ridiculousness, what is going on in North Carolina?
Well, I guess
who is the Attorney General?
Who is the Attorney General? The Attorney General's name is Josh Stein, and I'm going to find the tweet and pull it up for our viewers and listeners. I'll actually read the tweet. But I was kind of taken by surprise with this late last week. Norm, I think I sent this to you almost immediately as soon as I saw it. And here it is. So this tweet, June 22nd, 4:14 p.m. by Josh Stein. Now, something important to understand. Josh Stein is the state attorney general for the state of North Carolina. He's also running for governor in 2024, and he's running as a Democrat. There's currently a Democrat in office.
So he's deciding that he's not gonna defend a state law. What is the state law that's being challenged, and why is he not going to defend it?
The tweet reads, I support women's freedoms. After a thorough review of the case in Planned Parenthood v. Stein, I have concluded that many of the provisions in North Carolina's anti-abortion law are unconstitutional. My office will not defend those parts of the law.
Well, unconstitutional as a matter of state or federal law. Does he state constitutional law or federal constitutional
He doesn't discern. However, the lawsuit talks about, so they've moved for a temporary restraining order. That's to be heard on Wednesday. I'll get into more of the procedure in just a moment, but it's violation of the First and 14th Amendments, right? They've talked about, abridgment of the freedom of speech, violation of the 14th Amendment, which incorporates, as you know, Norm, certain privacy considerations.
Well, I thought that Dobbs versus Women's Health said that there is no federal right to abortion,
exactly right.
And that this was returned to the states. So why is his decision not to defend a challenge where the Supreme Court has spoken not grounds for impeachment?
I don't know, because here are the facts, as it were. Senate Bill 20 is a bill that was passed by the North Carolina legislature, and it was sent to Governor Roy Cooper to sign. He vetoes the bill. We've talked on this stream in this podcast a number of times now. North Carolina is a hot political battleground right now, but the Republicans enjoy a veto-proof supermajority in the legislature. As such, that veto-proof supermajority overrode Governor Cooper's veto in both the House and the Senate. making the bill as passed law in the state.
What does the bill do? What does it say?
The bill does a series of things. North Carolina's stance on abortion before Senate Bill 20 was up until 20 weeks access to abortion. What this bill does principally is it goes from 20 weeks down to 12 weeks with exceptions therein. And then those exceptions are sort of what look like something like rape and incest, so up to 20 weeks, up to 24 weeks for things that a doctor would call a life-altering anomaly within the baby. Then there are additional reporting requirements. Reading.
Hey, I got news for you. Babies themselves are life-altering anomalies. They're mysteries. They alter your life. You can tell us about that. But anyhow,
yeah. And so that's the important thing here. I think I sent you a text this morning, Norm, where I sent you another tweet from Josh Stein where he said something to what did he say? Do you remember what that is? His tweet was something like, Republican extremists in Raleigh know what they're doing is unpopular and that they can't win fair and square. So they're doing everything in their power to make it harder for you to vote. And it's just like
that's a non sequitur. One thing doesn't follow from another.
Absolute meme. He is a absolute meme, and he's a politician at this point. My biggest problem with this focuses on the fact that he is still in a position as Attorney General of this state. The fact that he's running for governor is not a priority, but it does seem as though he is now conducting himself in a manner not inconsistent with someone who has just abdicated his duties as North Carolina's top lawyer. Right. And he is wholesale into trying to become governor of the state. And as such, his rhetoric has changed to fit that.
So I'm just puzzled by the legal fundamentals. As I read Dobbs versus Women's Health, it basically said there is no federal right to an abortion. This is something that goes traditionally to the states, and the states are free to decide. And so North Carolina has made a decision and has restricted, apparently under Senate Bill 20, access to abortion in ways that hitherto were not the case. The bill has become law. Planned Parenthood has sued to enjoin or stop the enforcement of the law, naming Stein as a defendant. And Stein is saying, I think you're right, but if you're suing as a matter of federal law, is this somehow a left-handed challenge to Dobbs, saying that
absolutely, it absolutely is. So what's being done here is the Attorney General is signaling. It's interesting that he would do this because I think it actually makes them more vulnerable to public scrutiny. And we'll talk about this really quickly in a second. But yes, I mean, what he's doing, in my opinion, through reading the motion for the memorandum in support of the temporary restraining order, which everybody here we've talked about before, comes before a preliminary injunction, but it's basically saying we have a likelihood of success on the merits. We will be permanently injured if this doesn't, if this injunction doesn't issue or this restraining order doesn't issue, and we need to have it heard quickly there because what I think is happening is they are trying to quickly get something back in front of the Supreme Court on the same subject matter that was overturned.
So what would the claim be that the distinction is arbitrary and therefore in violation of due process?
It's anything that they can couch it under, right? Vagueness, inconsistent, unconstitutional. They've tried to reserve all of those arguments by and through their memorandum support of the TRO. What's amazing about this as well.
So who defends North Carolina's statute if the state's top lawyer won't do it?
Now we have had so the judge on the screen there has allowed, she has granted a motion. This is Judge Catherine Eagles, but she has granted a motion for both Senator Berger, who is he is the president pro tempore of North Carolina Senate, and she has also approved Speaker Tim Moore, who made this stream maybe last week or thereabout for his extramarital exploits. But she has allowed those two individuals to intervene as defendants on behalf of the state of North Carolina, citing precedent that was set in 2022, giving the legislature a keen and compelling interest in being able to defend actions like this that would seek to undermine or overturn a validly passed bill. Right.
So Stein knows whereof he speaks. There was a fascinating story in terms of politics, there was a fascinating story in the New York Times over the weekend about shifts in public attitude toward abortion after Dobbs. And what it showed is that after Dobbs, a lot of people have now gone from indifference to favoring abortion rights. And people who hadn't been forced to make a decision before now believe they are forced to make one. So I think that Stein is this is a blatant move to run for governor, but it's also an abdication of his responsibility as Attorney General. Is anybody going to try to impeach him? And what is the standard for impeachment of an Attorney General?
That's the next question that I think we should spend time talking about. I know you have a hard out, but we'll continue on this. This is actually one of the more fascinating stories for Law and Legitimacy to cover. It's kind of been gift wrapped to us and just fallen in our lap. The motion for TRO is being heard in federal court here in Greensboro, North Carolina on Wednesday. So I'm going to do everything in my power to make provision to be there. And I can report back just depending on what the outcome of that is.
Well, let's do that, but I do have to run. I'm on trial in a sexual assault case in a courthouse in Danbury, Connecticut today. I got about an hour and 15-minute drive, and I hope to be there on time because I don't think the judge would be amused if I said, Judge, I'm late because I was on Law and Legitimacy running my mouth about cases that aren't mine because I care about the country. So we hope you will return. We'll be back tomorrow morning. Mike, where do they find us? How do people support us? You know all that.
Absolutely. You find us here on Rumble Video, on Twitter Live, YouTube Live. Please subscribe, enable notifications, give us a like. Most importantly, follow us on Twitter at Pattis Podcast. We're building a nice following there. And we're going to actually be building out a website and getting your email so that we can connect with you directly over email. So be on the lookout for that. If you're not able to catch us every morning at 8 a.m. here live on any of those three platforms, you can always find us shortly thereafter at Apple Podcasts, Spotify, Google Play, Audible, Overcast, wherever you find podcasts. Law and Legitimacy. Rate us 5 stars or leave us alone. We'll talk to you tomorrow, Norm. Have fun.
All rise. No, please be seated. Oh, that was for the judge? Okay, I'm on my way. See you tomorrow, everyone.
Bye, Norm.